Hopefully everyone can hear me okay, and welcome to this employment rights webinar. We've got a really great number of attendees, participants here today, so it's so good to see that so many people have found the webinar and joined us this evening, and thank you very much for doing so. So just to introduce the webinar today, this webinar is set up by the Trust for London's Employment Legal Advice Network and also the Greater London Authority. So they are the organisers today. My name is Lucy Burrows. I'm going to be your speaker today. I am an employment lawyer, and in my day job, I currently work for BPP University and specifically for BPP's Pro Bono Centre. So I spend my time supporting our students, providing free legal advice and assistance in all sorts of different areas of law. The organisers have got a couple of points that they just wanted to make sure that I say at the beginning. Firstly, I understand that there may have been some issues with registration. A few people may have been asked to register twice for this event. So if that was you, I apologise for any confusion or inconvenience that caused, and really pleased that you've got into the webinar and that you've made it despite that. Also, people can turn on live captions to this webinar, I understand, if they would need to or would like to. And I believe, you have to excuse me, I'm reading from what I've been told, but you click live transcript and show subtitles, and that should allow you to put on some subtitles on what I'm saying today. Also, just to let you know how we're going to be running things today, we've got just under an hour until 7 o'clock, and this is going to be a presentation webinar, so there is going to be quite a bit of me talking at you, but hopefully with some useful information that's going to cover off some of the questions that you might have come with today. And then we will be doing, as best we can, a Q&A session. So I will do my best to answer questions that people put in, but I'm not going to stop and answer questions as we go along. So if you pop in a question and I don't respond to that immediately, please don't feel that I'm ignoring you, because I'm certainly not. But what I want to do is make sure that we get through the whole presentation so we get as much information out to as many people who are participants today as we can. And then as I'm talking, if something occurs to you, or if you've come armed with a question already that you would really like answered, put that in the Q&A box and I will go through that. I can see that somebody did ask in the Q&A box, and I will answer this one, whether there is going to be a recording or they should take notes. You might want to take notes of the session if there's anything that's particularly important, but I understand that this session is being recorded, so there should be an option to access it at another time. But you know, I do recommend, if there's anything in particular that is really significant for you, that you might want to take a note of that. It's also worth saying that we are going to be sending out a document with sources of further advice. And that's going to be really important. That's going to come out later this week, I believe, and that will be sent to the email addresses that you registered with. So that document will be coming out to you, and that's going to have the links for lots of different advice agencies and organisations where you can get further advice. So that means if you don't hear exactly the particular legal point that you need today, or you ask a question and we don't manage to get onto it, well, you will still be able to then find some resources or some legal advice where you can have a bit more time getting your particular question answered. I think that's all the introductions, and we now have quite a few people that have joined while I've been talking. So without further ado, I'm going to move on to the presentation. So what is the objective of today? What are we trying to achieve? Well, our presentation today is really to help you try and improve your understanding of some of the following employment law, employment rights issues. So to understand what status means in employment law context, we're going to be talking about furlough. You won't be surprised to hear. We're going to be talking quite a bit about redundancy and what you can expect in a redundancy situation. And then we are certainly going to be talking about what to do next if you need further advice. So the topics that we will cover will be the employment status point, it will be the furlough scheme, the meaning of redundancy, and in particular, what you should be expecting in that situation. So covering consultation, selection for redundancy, and importantly, redundancy pay. We're going to be touching on discrimination issues, but that could be a whole topic in itself. So we will just be touching on those today. But again, we will be able to give you some signposting as to where you could go for further advice on any discrimination issues. And we will also be talking about the relationship between furlough and redundancy, and what happens if your employer closes, and particularly what happens if they close in a situation where they could be where they could be insolvent. The first thing I want to talk about, though, before we dive into the issue of redundancy, is status. And by status, I don't mean how important or high up you are in the organisation that you work in or how senior you are. I mean your status in employment law. And this is really important for people to be aware of, because there's lots of rights within employment law in the UK which affect the way that the rights and protections that you have in the workplace. And there's various different ways you can be engaged in the workplace. So the first one, and the person who has the most rights and the most protections, would be as an employee. Coming next in line is if you are deemed a worker. So not quite as many rights and protections as an employee has, but still lots of statutory rights that will apply to you. And finally, somebody who is self-employed. So you might be known as a contractor or a consultant, but ultimately you are classed as self-employed. Now, there's lots of advantages to being self-employed, but self-employed people do have essentially the least employment rights and protections. So it's really important to have an understanding of what you are in the workplace. Are you an employee? Are you a worker? Or are you self-employed? And it's not always that obvious. You might not have any kind of written contract at all, but you might have been told that you have no employment rights because you've not got a written contract. Or you might have been told, you might have a piece of paper maybe even that says you are self-employed. Neither of those things should necessarily be taken at face value. Just because you don't have a written contract, firstly, does not mean you don't have any employment rights. Employment rights are from law, from statute, so you will still have rights. And secondly, just because somebody has told you you are self-employed or even put that in a document, doesn't necessarily mean that is genuinely the situation. As employment lawyers, status, so what your employment status is, really depends on the facts of the relationship. So it depends on what happens in reality, not on what is labelled on a piece of paper. So as an employment lawyer, if you were assessing whether somebody is genuinely self-employed or could they really be an employee, you might be looking at their working patterns. How much is that working pattern a regular thing that they do all the time? The kind of work they do, is that closely managed by someone else? Is it very prescribed by the person they work for? Whether they have to turn up for work themselves or whether they could just send someone else to do it, such as a substitute. And whether there's an expectation that they turn up for work, even if they don't want to. And the more control there is over somebody, the more that the person who engages them designates exactly what they do and how they do it and when they do it, the more likely it is that actually they might be an employee despite what their documentation says. Employees, it's worth saying, you could be full-time, you could be part-time, you could be fixed term in that there is an end date to your contract at some point, or you could be permanent, that there's no end date. You might work fixed hours every week, or you might work very varied hours every week, and all of those things could still be an employee relationship. You could still be an employee. I'm not going to go into more detail about this, but you will hear me talk about status and whether or not you're an employee as we run through the presentation. So it was important to go over it. And if you think this might be a point of concern to you, if you're thinking, gosh, you know, I've been told I'm self-employed, but I'm really not sure now I've heard this, you can find out more information. a great place to start for that is the Mayor's Employment Rights Hub. And I'm going to ask my colleague Lizzie, who is here on the session with me today, to publish that web link so you've all got that. So she will publish that in the answered questions. But as I say, you're going to be getting more information off us about places to go for further advice anyway. Okay, so moving on from employment status to the furlough scheme. It's really weird to think, isn't it, that at the start of 2020, furlough is not a word that was used much in London and beyond by anyone. And it didn't really mean much outside of the world of employment law. But now it is something since the beginning of the COVID-19 pandemic that we have probably all heard of, the furlough scheme. So furlough is essentially a period of absence from work. In life before COVID, if anyone was absent from work, they were on holiday, they were on sick leave, maybe they were on maternity leave, but now we have a large amount of people who are absent from work on the furlough scheme. Now, the furlough scheme has been evolving and changing and adjusting ever since it came into force, ever since it was first announced by the Chancellor back in spring of this year. But as things stand at this moment in time, at the point of speaking, the furlough scheme has been extended until March 2021. So we have a bit more time to run on it at the moment. Some important points to know about the furlough scheme. Any employer of any size is eligible to use that scheme, whether they're a business, a large business, a small business, a charity, a recruitment agency. Any employer is eligible to use that scheme. You can be furloughed if you are full-time, if you are part-time, fixed term, 0 hours contract, flexible contract. However, you must be an employee or a worker to be placed on the furlough scheme. It is not applicable to self-employed individuals. Furlough was introduced as a measure to keep jobs open. So the idea is that employers can use the furlough scheme to keep people employed, so you remain employed if you are placed on furlough, and keep them paid at a capped rate, so keep them paid at 80% of their usual rate of pay, subject to a cap, a monthly cap of £2,500. So if you're on here and you're fortunate enough to usually have a monthly wage above that, but you are on furlough, the furlough is capped at that. And essentially, it is a benefit for employers. Employers are able to place employees onto this scheme and claim back that 80% of wages from a government grant. So it is really essentially a way to try and keep people in work, keep people employed, keep them on the payroll at this point in time when so many businesses are struggling. Your employer, however, isn't obliged to use furlough. It is a decision for the employer. And unfortunately, for some businesses that are struggling financially, they will feel that they have no choice but to consider reducing numbers, but to make job cuts. So furlough is not going to be an option for every single employer and every single individual. And with that in mind, let's move on to talk about redundancy. So redundancy, if you're told you're not needed for work anymore, or you're told that your contract is going to be terminated, you're going to be dismissed, you may be in a redundancy situation, you may have the benefit of redundancy rights. And I can see from some of the questions that we've had that some people are indeed in that situation and are asking some detail about their own redundancy situation. But we're going to talk for now about this in quite general terms for the benefit of everyone on this webinar, so everybody has a good understanding of what we mean by redundancy. What does a redundancy mean exactly? Well, a redundancy is whereas there is a dismissal from work in a situation where the employer needs to reduce the size of its workforce. So it could be that a business is closing down. It could be that it doesn't need as many people to do a specific job anymore. For example, a business might provide cleaners to offices in London. Well, those offices are not being used at the moment. They're very quiet. They don't need the cleaning that they used to use. They may need to reduce that team down to a lesser number. Or it might be the business doesn't need people doing a certain job in a certain location. So maybe the London arm of the business is closed, but the Manchester one is still open. That would still be a redundancy situation. And it's important to know that a business can't just make up the idea that they don't need you to do any work anymore. There has to be this concept of a need to reduce the size of the workforce if we are in a genuine redundancy situation. And if we are in a genuine redundancy situation, then it is obviously possible for employers to terminate employment in that situation, subject to them following a fair procedure and subject to certain rights that people will have in that situation. So you may be entitled to those redundancy rights, including the requirement for your employer to follow a fair procedure, so certain minimum standards that they must comply with, if you are legally classed as an employee, and also if you have worked for your employer continuously for 2 years. So they are the two things that you will need to benefit from those redundancy rights and protections. Assuming that those are there for you, let me just move my slide on actually. Yeah, assuming that those things are there for you, you should be expecting to receive notice of a potential redundancy and also to be consulted about that redundancy. And this should involve meeting with your employer, usually at least twice. You know, in this time, that meeting may not be in person. It may be done remotely. It could be done over a video call like this. It could be done over the telephone, but certainly a meeting with your employer. You may be offered the right to bring a companion to that meeting. That's not always the case, but a lot of employers will offer that. And if they don't offer it, you can always ask. And that companion would usually be someone from a trade union, if you're a member of a trade union, or if not, possibly a colleague that works with you, someone to accompany you to that meeting if you wanted. At that meeting, you should also be told about other jobs in your organisation and be given the chance to apply for them to the extent that they exist. And you should be informed about what money you are going to take away from that redundancy process if you are dismissed by reason of redundancy, in particular, what your redundancy pay would be. And you should also, if you are ultimately dismissed for redundancy, be given the opportunity to appeal that decision if you'd wish to. The meetings that you attend should be a proper conversation, not you just turning up and being told in 2 minutes, sorry, we're cutting the workforce, you're going to be made redundant. They should be a meaningful conversation where you get the chance to ask questions, to make suggestions, and to fully understand why you might be being made redundant or what is going to happen next. If then there may be some people on this call that this applies to, if your employer is making a lot of redundancies, so for example, if your employer is going to be making 20 or more people redundant, then the process will look a little bit different. In that situation, a consultation period for redundancy, the period of discussing it would potentially be longer, and also it would be done by either trade union or employee representatives in your organisation, and if they don't exist already, they would have to be elected for that process out of the employee pool. So I'm not going to go into lots about collective redundancies, but just be aware that if there are a large amount of redundancies going on, you might find that other people, other employees or trade unions are representing you at those meetings, and that would be normal in that situation. And if that is the case, you should use those people and ask them as much as you want to know about the redundancy situation to be sure that you really do understand things. Okay, so moving on to the next thing that you should be aware of, and that is selection. It's possible that only some people will be selected for redundancy. You know, for example, there may be 20 people, 20 employees who do the same role in a hotel chain, and it may actually be that the business wants to reduce that to 10. So only 10 of those people are going to be selected for redundancy. And in this situation, employer has to choose people, select people on a fair basis. So the selection should be objective and measurable. There should be some clear criteria about that selection, not based on subjective opinions or who people are friends with or personalities, but actually things which employers can objectively score employees on, assess their performance on. So it might be performance or attendance, timekeeping, amongst lots of different other things, depending on what job role we are considering. So it should be very clear the basis on which people are selected for redundancy. And there are certain things that should never come into selection for redundancy. These are known as protected characteristics, and it is unlawful to discriminate against people on the basis of those characteristics. And that's what I'm going to touch on next. So it is unlawful to be selected for redundancy on the basis of, and I'm just bear with me a moment so I can see my slides here as well, on the basis of sex, or whether you're male or female, on the basis of your race or your national or ethnic origin, on the basis of sexual orientation, on the basis of your age, if you are somebody who suffers from a disability, on the basis of your religion or your belief, on the basis that you have undergone or are undergoing gender reassignment, on the fact that you are pregnant or on maternity leave, or on the basis of your marital status, whether you're married, in a civil partnership or single, amongst other things. And there are some other things that should never come into a redundancy selection. So if you are a member, or actually you've chosen not to be a member of a trade union, your working pattern, so if you're, it would be unlawful to just purely select people on the basis that they are part-time only. The fact that you're on paternity leave or parental leave or dependence leave, the fact that you've exercised a statutory right. What do I mean by that? Well, statutory rights might be things like being somebody who takes your annual leave, as is your statutory right, takes your rest breaks, as is your statutory right. You shouldn't be selected for redundancy on the basis that that is something you have done or want to do. The fact that you are a whistleblower, what I mean by whistleblower is somebody who has made a disclosure about some kind of wrongdoing on behalf of their employer, or the fact that you take part in or have taken part in lawful industrial action, and usually that would mean some kind of strike action, or things like if you're doing jury service. Any of these factors should not be taken into account in selecting somebody for redundancy. So what if you think your redundancy might be unfair in some way, unfair in the way that the process has been run or the selection or in some kind of way? Well, if you're an employee and you have more than 2 years service and your employer doesn't have a genuine redundancy situation or they've not followed a fair procedure, you could take steps to appeal the redundancy, of course. And if that's not successful, we would recommend in that situation that you do look to seek some kind of legal advice, because if an appeal is unsuccessful or you're not even offered one, there is potential that you could have a claim for unfair dismissal. So you may have the ability to bring a claim in the employment tribunal. Now, claims in the employment tribunal do not necessarily need a lawyer to run them for you. As an individual, you can be a litigant in person in the employment tribunal. You can bring your claim and there are no fees to pay. But I will say 2 caveats to that. Firstly, bringing a claim in the employment tribunal is complex and time consuming. So it is, although absolutely possible, it's not something to take lightly. It is quite a complex process. And because of that, I would really recommend seeking some legal advice if you are thinking you may have a claim and you want to bring an employment tribunal claim. Because just seeking some initial advice and some free legal advice from one of the sources that we will give you at the end, and one of them is my own organisation, the BPP Pro Bono Centre, who have an employment law telephone advice line where you can have 40 minutes or so telephone meeting with a volunteer lawyer that can go into the detail of your situation. Getting that initial advice on whether you could have a claim and whether that claim has reasonable prospects of success would be really valuable. So we definitely recommend you do that if you think you might have a claim. And secondly, a few things to be aware of if you think that might apply to you. The first is that the time limits for bringing a claim are extremely strict, extremely strict. You have to bring your claim in 3 months from the act complained of. In fact, the way it technically works is it's 3 months less 1 day, so just slightly under 3 months. So, for example, in a redundancy situation, you would be bringing your claim from 3 months of the date at which you were dismissed. And you also, the other second thing for you to be aware of is to bring a claim, you need to make contact with an organisation called ACAS, ACAS, which stands for the Advisory, Conciliation and Arbitration Service. And they will essentially go through a process with you and your ex-employer to try and resolve the dispute pre-tribunal. And if they can do that, great, brilliant, you may reach a resolution. And if not, if it's not possible or neither of you want to engage with that, well, then they will issue you with a certificate confirming that you've tried this process and a unique reference number that you then need to go ahead with a claim. So those are the things to be aware of, and do look at those further sources of advice if you think you want to do that. What if you're not an employee or you've got less than 2 years service? Well, firstly, think about your status. Could you be an employee? You know, is the fact you're being told you're self-employed definitely absolutely correct? Secondly, think about whether your dismissal could be unfair in some way because you've been selected on a reason which is related to race. So think about, or not just to race, but to any protected characteristic or discriminatory reasons such as race or age or disability. Think about that, because in that situation, you would not need the requisite 2 years notice to be able to bring a claim. But as a minimum, even if none of those things apply, even if you don't have those 2 years service, it's not a discriminatory issue. As a minimum, you should still be paid for the work you have done, and you may be entitled to notice and other benefits such as pay for accrued but untaken holiday. Let's look then at redundancy pay. What are you going to be entitled to? So if there's a genuine redundancy situation and a proper procedure is followed, well then you would be potentially entitled to redundancy pay if you are an employee and you have that accrued 2 years service. How much you would get depends on a few different things. It depends on your age and how long you've worked for an employer. And you might get more than the minimum that the law says if you have any kind of enhanced redundancy policy as part of your contractual arrangements with your employer, but that is quite rare. Usually we are looking at a statutory redundancy. There is a statutory redundancy pay calculator that you can use to try and help you work out exactly what your redundancy pay should be. And that is on the gov.uk website. If you just Google redundancy pay calculator government, it will come up immediately. And what you'll need to know to use that is your weekly pay before tax and other deductions. That will be based on your redundancy pay will be based on your earnings before tax, the years you've worked for your employer, and your age. And your weekly pay should include, as well as just your basic wage, any regular contractual overtime you get and any contractual bonuses or commissions. On the next slide, you can see that there is a table which shows how redundancy pay is calculated, and you can see how it is broken down into age. So it is different depending on your age bracket. I'm not going to read this table out in detail because hopefully everyone can see that clearly on the slide, and it is admittedly quite complicated. But what you should be aware of is that your employer must tell you in writing how your redundancy pay has been worked out for. So it is for them to calculate this and tell you this. But if there's anything you're not sure about, if there's anything you think is not quite right, you can look at this. This is readily available, this table, again, on the government website. You can go to that redundancy pay calculator, and that's something you would be able to raise at a consultation meeting. Query why your redundancy pay is perhaps not quite as you're expecting and ask your employer to explain that. As well as redundancy pay, what else might you be entitled to if your work is no longer needed? Well, you'll also be entitled potentially to other payments such as payment for notice, holiday pay, pension contributions, and more, depending on your circumstances. And your circumstances are going to include, like I said before, your status and what's set out in your employment contract. A big one is probably going to be notice, and things can get a little bit complicated when it comes to notice. I'm sure most people probably understand what I mean by that, but notice is essentially the period that your employer has to give you in advance of telling you that your employment is going to be finishing, and it's normally reciprocal. So there'll normally be a notice period that you have to give your employer as well. Often there will be an employment contract which sets out what notice people have to give to each other, but everyone should be aware that there is also something called statutory minimum notice. So statutory minimum notice is the minimum amount of notice that employees must be given by law. So it starts at 1 week's notice, if you've been employed for a month or more, and it goes all the way up to a maximum of 12 weeks notice, and essentially you accrue an entitlement to an extra week's notice for each full year that you've worked. So if you've worked 6 full years for an employer, you would be entitled to a statutory minimum notice of 6 weeks. That statutory minimum notice, if it is greater than that set out in your contract, so for example, if you're that employee who's worked for 6 years, but your contract of employment says you just get a month's notice, in fact, the greater statutory minimum notice applies. So you wouldn't just get a month, you would be entitled to 6 weeks. If your contract is more generous than your statutory minimum notice, maybe you've only worked there for 3 years, but it says you get 3 months notice, the contractual notice period would apply. So whichever is the greater is going to apply in that situation. In the event of a redundancy, sometimes an employer will require you to work your notice, or sometimes the employer will just give you a payment in lieu of notice. And that is going to be a decision for the employer, but often it will end up being a payment in lieu of notice. You might also be entitled to receive payment for holiday that you've earned but you didn't use. So again, people are entitled to a statutory minimum number of days holiday, 28 days holiday in a employment year, which might run from January to December, or it might be slightly different in the way your employer runs their holiday year. But if you've not taken your prorated, so your holiday entitlement that you have accrued up to the point when you are dismissed by reason of redundancy, then you should be paid for those accrued holiday days. So that's another payment that you would be able to expect in a redundancy situation. Okay, just a couple more things that I'm going to touch on until we try and get through some of the questions that I have seen. Okay, what happens if I think I could have been furloughed instead of being made redundant? That's a question that we have actually been asked, and one that we were going to cover anyway. Well, there's no way, unfortunately, to force your employer to furlough you rather than making you redundant. But you could, of course, try speaking with them, try talking to them about whether or not this would be an option in that situation. It may even be possible to find someone to help you with this. And I've mentioned on the slide the Draw Mediation Service. So that is a mediation service for Londoners, which is based on finding solutions through conversations and aimed at resolving and supporting employees to resolve issues in the workplace. That mediation service is going to be listed in the information sheet that will be emailed to you with sources of further advice. So, you know, if you think furlough might be an option, but your employer isn't using it, all you can really do is just talk to them and explore that with them, and, you know, seek an explanation as if it's not applicable, why not? What if you're already on furlough? This is another thing people have been asking. Is redundancy a risk? I'm afraid it is. If you are on furlough, your employer is still able to start a redundancy process. So it means it is still possible to be made redundant in this situation, even though the hope is, obviously, that employers are using furlough as a way to avoid redundancies, and that ultimately you will come back from furlough and go back into the workplace, but it is a possibility. If you are on furlough and your employer starts a redundancy process, you are still entitled to all the employment rights that we have talked about. So you should still be having a consultation process with your employer. Now, that consultation might look a bit different to how it would in the workplace. If you're on furlough, if you're at home, that consultation process might be happening on a forum like this, online or on the telephone, but it should definitely still be happening. Now, the furlough scheme, and in particular its relationship to redundancy, is not straightforward in the way those two things interact, and it has also been evolving. But I'm going to talk about it with the position as at December 2020, so what the position currently is now. And the position now is that employers cannot use the furlough scheme to cover periods of notice or pay in the event of a redundancy, which means that if you are made redundant, your period of notice or any notice payment will usually be at your pre-furlough rate of pay, not your furloughed rate of pay. There are a few complications to this, particularly if you've been on furlough for a long time and your furlough agreement that you had with your employer, what you signed way back when, many months ago, sets out detail about what happens with notice and the interaction between furlough and redundancy. So it's advisable to have a look at that. And ultimately, the only thing I can really say about individual circumstances is ask your employer to clarify the level of pay for the notice period or any payment in lieu of notice. And if they say it's on furlough pay, ask them to clarify that that is legally correct, because there has been a change from this month, which means that it should be on the pre-furlough rate of pay. Another thing to note about the relationship between redundancy and furlough is that since July 2020, employers have been required to base their calculation of statutory redundancy pay, so that calculation that we looked at on the screen, on pre-furlough pay, not on that reduced 80% rate. That can be quite important, particularly if you are an employee who doesn't work normal working hours. So if your hours really varied before you were furloughed, and your redundancy pay then has to be based on an average of the hours that you worked over a period of time, that would usually be based on an average of 12 weeks work, and an employer has to look back at the 12 weeks before you went on furlough to take that average. They can't use the furlough period, and they also can't forecast ahead and think, oh, well, if you were back, you would have worked this. They have to look at that pre-furlough period. That has been the case since July 2020. So there are some complications and with that relationship, and it can be quite technical. And again, we may not be able to get to individual circumstances today, but that's where we would advise you to seek some further advice. This is something you really need to ask. I've just noticed a note from my co-host saying that a participant or some participants have raised their hand. If you've got your hand raised and you've got a question, could you pop your question into the chat box? It won't show as immediately published to everyone, but I am going to try and get to questions in the chat box over the next 20 minutes or so if I can do. So if you've got a question, you've got your hand raised, pop that question in the chat box and we will get to it. Okay, so the last thing I want to talk about before we go to some questions is just what happens in the tricky situation of an employer going insolvent. It's definitely something that's happening. It's very difficult times. Lots of businesses are struggling, and it's important to know your situation in law can really change if the business you work for is insolvent. There's a difference to a business simply closing down and deciding that it's going to close for now or it's going to stop trading for now, but still existing and being solvent. And they have to wrap up their affairs, so pay their employees and the self-employed contractors what they owe them. A business going insolvent, also known as going bust or bankrupt, you may have heard, that is when the business has less money than it needs to pay its debtors, and it is classed as insolvent. And that business will be passed in its entirety to be taken charge of by what is known as an insolvency practitioner, sometimes also known as an official receiver. So they're the two terms to be aware of: insolvency practitioner, official receiver. If you get contacted by one of them, if you hear about one of them taking over a business you work for, it's very likely to mean that business has gone bankrupt, it's gone insolvent. There is a common misconception that people think that is the end of it. I'm not getting any money out of this business. There's nothing that I can do to get my wages back. That is not necessarily going to be the case, although it is admittedly a tricky situation. The insolvency practitioner or official receiver must tell individuals how their job is affected and what to do next, and they should be providing individuals, employees, with two important things: an RPI fact sheet and a case reference number. And that will then allow those employees, those two items, to put in applications to recover the money owed for them. So if you're aware that the business you work for has gone insolvent, ask for those two pieces of information from whoever is wrapping up its affairs. With that, you may then be able to apply to the government for a redundancy payment, holiday pay, outstanding payments due to you, such as, importantly, wages, overtime, commission, and money you would have earned had you been able to work your notice period. So that is really important if there's anyone on this call that is here because they have got an insolvent employer. It is important to know that there are options for you to follow. Again, if it's something that you think you will struggle with to explore on your own, we will be sending out that sources of advice, and there's various organisations on that could talk you through that practice. Okay, so that is going to conclude the presentation that we have talked about, the bulk of the presentation that I'm going to be talking about, and I'm now going to go to some questions. I've got some questions that have already been sent in, and just looking at some of the questions we've got in the box here, some of them are a repeat of those questions. So what I am going to do is I'm going to run through the answers to some of those on the mic. If you've given me kind of personal information in those questions, like if you've told me the name of your employer, please don't worry about that. I'm not going to disclose that over the mic. I'm just going to answer these in more kind of generic terms, but hopefully that will answer your questions. So we've got lots of questions about redundancy and the relationship between furlough. So I'm just going to run through some of those, and they'll obviously be useful for the person who's asked them, but I'm hoping they'll be really useful for more people on the call as well. So somebody has asked, if I'm being made redundant while I'm on maternity leave, does an employer have to pay full notice period if someone is being made redundant? So do they have to pay your notice period out? And should that person have to use their holiday days against their notice period, or is this a form of an unlawful deduction? Okay, so this is actually a much more complex question than it might appear. And it's the relationship that we're talking about between maternity leave and redundancy. So you can be made redundant if you're on maternity leave. And this specific question about notice, an employer has to pay you your statutory notice. So we talked about the concept of statutory notice and maybe a bigger notice that you might be entitled to in your contract. An employer has to pay statutory notice if they make you redundant on maternity leave, yes. But if your contract of employment gives you at least 1 week's more notice than your statutory notice period, you will then have to rely on that notice period in your contract. And that means that notice pay will only be payable during maternity or parental leave if it is stated in your contract or your employer agrees to pay it as part of the redundancy package. It's quite a complicated answer, but I'm really sorry, it's quite a complicated question, actually. That the person who asked this question also needs to bear in mind that if your period of notice overlaps with your 39-week entitlement to statutory maternity pay, then your employer is entitled to offset that. Okay, so they're entitled to offset the statutory maternity pay against statutory or contractual notice period. You don't receive both for the same period of time. And in answer to the last bit of that question, no, if you're still on maternity leave, you should not be forced to use your holiday entitlement during a notice period. So holiday accrues during maternity leave as it usually would, and you would be entitled to receive a payment in lieu of that accrued but untaken holiday. Okay, so I hope that is helpful to the person that asked that question. Okay, the next question that I've got that I'm going to answer is, should outstanding leave dates be paid if someone has been furloughed and will be made redundant? And by leave dates, I'm assuming that this person is referring to holiday. Yes, if you have accrued but untaken holiday and you've been on furlough, you've not had the opportunity to use that and you're made redundant, that accrued holiday should be paid at the pre-furlough rate of pay. Okay, the next question is quite complicated and it is specific to this person, but I can see that they've asked it in advance and they've asked it in the chat box as well. So I'm going to answer it for their benefit. This is about bonuses. And it says, will someone receive a no sickness bonus? I'm assuming that this is something that they get if they have very good attendance at work. If it is in the contract, and they normally do every year, if their employer is going through a business rescue. Would this be paid by the government at 80% as the employee's on furlough, or is the government not required to make this payment? And would this be capped at £2,500 or considered differently? So quite a few questions there, but I think ultimately this is where we are with it. It partly depends on the exact terms and wording of that bonus. So contractual bonuses to which you are entitled by contract every year arguably form a part of wages, so could be included in that 80% payment, that 80% furlough payment. A discretionary bonus probably would not. So if a bonus is mentioned in an employment contract, it could be contractual, but without looking at the document, it could still be discretionary. Sometimes things are referenced in the employment contract, but ultimately their status is still discretionary, which means they're not part of wages. They are a discretionary bonus. Even if it is a contractual bonus, so in any event, yes, the cap would apply because this is an absolute. So if that bonus took wages over £2,500 or 80% of wages over £2,500 in that month, you still unfortunately wouldn't receive any more than that if you are furloughed. I hope that helps answer that question. If the person who asked that is still unclear about the status of their bonus and how that would work, seeking some further advice on that, where somebody has got the time to look at the documents with you, might be really useful. Okay, does the law dictate, this another question, does the law dictate the order in which employees should get sight of and be offered any vacancies in a restructure? So this is the employer's obligation to think about and consider suitable alternative employment for employees, or should they all have the opportunity to express an interest at the same time? So we've talked about the duty to consider suitable alternative employment on behalf of employers. The answer is, as always, one thing, but then with a caveat. Always seems to be the case with lawyers, doesn't it? Generally, vacancies always have to be shared with all at-risk employees, but there are some limited exceptions to this. So employees who are at risk of redundancy are on maternity leave, adoption leave, or parental leave have special protection in this regard, and they have an automatic right to be offered those suitable alternative vacancies. So they are top of the queue. They are priority for suitable alternative employment. Also, in some circumstances, employers might ring fence, which is what we mean, kind of siphon off and keep to one side certain vacancies for particular groups of people or particular job roles that they feel naturally move into that suitable alternative employment vacancy. And this can be an acceptable practice. It depends on the facts and circumstances. It can be an acceptable practice in large-scale redundancies, but it's not necessarily. So again, if it's a point of contention, contact one of the advice agencies, seek some advice on your personal circumstances. Okay, quite a couple of quite general ones now that I hope will be of interest to quite a few people. Does someone's notice period count towards the years worked when calculating statutory redundancy pay? So this is, if I just flick back in my slides, this is going back to this graph here and how your statutory redundancy pay varies depending on the whole year's work. And you can imagine a scenario, can't you, where somebody is right on the cusp of having, worked 5 full years, but they're just under it, and then they get made redundant, they get paid in lieu of notice, and they don't quite get there. So what is the situation? Well, the answer is statutory notice, so statutory minimum notice that we've talked about. Yes, it does count towards calculating the years. If an employee is dismissed without notice or with less than their statutory minimum notice, then the calculation date is the date on which their contract would have ended had the statutory minimum notice been given. A more generous contractual notice period, that won't count in the same way, but statutory minimum notice period, yes, you might be able to use that to push you over the year and slightly increase your redundancy payment. And another one that has been asked is if an employee is on furlough and not being made redundant, How much notice does the company have to give before they ask them to return to their jobs? And this person in question has said this question is interesting to them because they need to sort their childcare out. So this is a common problem for people who are either on furlough or since the beginning of the pandemic have been working from home, that they could be required suddenly to either go back to work or return to working in the workplace. And it's tricky. It is absolutely tricky because essentially there is no minimum notice period required unless it is stated in a furlough agreement between you and your employer. And the same applies to people who are working at home and could be required to go back into the workplace. So you could be required to go back in pretty quickly. Practical suggestions to ensure this doesn't cause you a problem. Well, firstly, obviously, one thing, I'm a parent myself, I know that this is very difficult, but try and ensure you've got your childcare in place or you've got it lined up. Try and keep your childcare open if you can, so you are ready to go back into work if you think it's likely you're going to go back in very soon. Or alternatively, talk to your employer in advance, have an open conversation with them and explain that difficulty, talk about that issue, and just ask them honestly how much notice that they think they might be able to give you, and explain why you would need the maximum possible. So, you know, all you can really do is try and be open and honest with your employer, but there is no minimum period of time. Okay, we've got about 5 minutes and I am going to try and zip through some of the questions we've got here, and I won't be able to get to all of them. I'm really sorry, but you will get your sources of advice leaflet. I'm going to try and choose ones that I think might be appropriate to a maximum number of people on this call. One really good question is, what if an employer wanted to reduce your hours of work? Can they do that? Yes, potentially they can try to. So this is going to depend what type of work, what type of contract you do. So if you have regular hours of work, let's say you work 30 hours a week at the moment, they want to, or you work a 5-day week, they want to reduce that to a 4-day week. Let's assume that is the scenario. That is a change to your contractual terms and conditions. And an employer can't just unilaterally impose that change. They can't just say, right, we're imposing that change, that's it, from now on your 4-day week. They have to go through a consultation with you. So they have to talk to you, they have to explain the reasons, and they have to seek your agreement. Can you refuse? Yes. In theory, you can refuse because it is a unilateral change to your terms and conditions. But if you do refuse, an employer has an option, it's quite a severe option, but it is an option to dismiss you and then offer you immediate re-engagement on those lesser hours. And if they do that, although technically you would have a claim against them, technically you would have an unfair dismissal claim, it's going to be quite limited because you wouldn't have significant losses. You'd only have that proportion of loss in wages. So, you know, if that happens, they can't just do it without consulting with you, but it is something that we are seeing many employers trying to do. And if it's proposed to you as an employee, it might be an alternative to making lots of people redundant. Somebody has asked me, how much notice does a company need to give me with 22 years of service? 22 years of service, wow. I mean, oh my goodness. So your statutory minimum notice period is going to be 12 weeks because that is the maximum. But if you are entitled to more notice in your contract, then that is the notice that you should be given or paid in lieu of, okay? So if you have been there for 22 years, unfortunately, it's not statutory minimum notice of 22 weeks. It is limited to 12 weeks. Somebody, I'm just trying to see, somebody has said, what are the 2 things we must ask for? I think that must be in relation to insolvency, because it looks like that question popped up then. The 2 things that you're going to ask for, I'm going to just reconsult my notes and double check that I'm saying this correctly. An RPI fact sheet, that's R for Robin, P for Percy, I for Igloo fact sheet, and an insolvency case reference number. If you are facing an insolvency situation, please do Google employment, business, insolvency, government website, and you will find there is a whole really good section on the government website about what you can do if your employer has gone insolvent. Okay, let me see if I can just take one more question. As a 0-hour contract, do you have the same right as full-time staff when it comes to redundancy? So if you are an employee on a 0-hour contract, you still have all the rights that I've talked about, but your calculation for redundancy will be based a little bit differently, because obviously you don't have the same fixed hours every week. So they will then essentially, when they're thinking about things like notice pay, they will be looking at, that when they're doing those calculations, they will be taking an average of the 12 weeks that you have worked previously. And if you're on furlough, that average will be that pre-furlough time to work out what your hours are in doing that calculation. So to essentially work out what your average pay was. So yes, you have the same rights, but the calculation will be a bit different. And if you don't understand it, please do ask for it to be broken down clearly by your employer so you can see exactly how they've calculated it. And again, that's the sort of thing that you could get one of the advice agencies or someone like Citizens Advice to help you check through, so you're confident that it is correct. Okay, I have got 2 minutes, so I'm just going to answer a couple more if I can. Can I be put on redundancy while I'm on holiday? Horrible thing to happen, but unfortunately, yes, you can be. But you can't just be ignored because you are on holiday. Your employer has to find a way to consult with you, to engage with you and start a fair process while you're on holiday. It's quite tricky to do that with someone on holiday, particularly if they are not contactable. So often employers will avoid that situation. They will start a redundancy process when someone returns from holiday. But if you're making a large amount of people redundant, sometimes it's impossible to avoid it with absolutely everyone. But in theory, yes, you could be made redundant, or they could start a redundancy process while you are on holiday. And can an employer say that redundancy pay is included in statutory notice pay? No, they're two different things. So your statutory notice pay is your notice that you're entitled to, and your statutory redundancy pay is a different entitlement which is on top of that. So if they are saying that it's all wrapped up in one, you want to see a breakdown of that. And if it doesn't look right, please seek some legal advice to clarify it, because hopefully they're being genuine, but it is possible that that is not correct and you're entitled to more. Lizzie, we are about 1 minute to 7, and I know we've tried to fly through as many questions as possible. We've not got through everything, and I'm really sorry to people that we've not been able to answer your particular questions, but I'm just going to say again that you will be receiving a sources of further advice document that is going to be emailed out later this week, there are lots of different types of advice agencies in that. So it's web links that you can go to get more information, but it is also places which will offer you legal advice. So that might be online legal advice. It might be a telephone appointment with a volunteer solicitor. It might be an appointment with a law centre. There are lots of different options. So if your question hasn't been answered, there's something you're really still unsure about, just keep an eye out for that coming through and do access one of those advice services to try and get those questions answered. And for those of you who've put slightly more complicated, detailed questions in the box, which are very specific to your personal situation, I would really recommend that you do that, because it means that you have got more time with a volunteer lawyer who can really help you go through your specific situation. But I hope the questions that we have answered have been useful, and I really hope that the webinar itself and that the run through on the information about status and furlough and redundancy has been useful. And just a really big thank you to everyone who has dialed in and everybody who has given up an hour this evening to listen to us talking, and I really do hope it has been valuable for you. I am going to stop sharing my video and my mic now, and that is going to conclude the session. And thank you so much to everyone for joining, and the organisers will be in touch with that further information as to where you can get more help. Thank you very much, everyone.